On this morning's docket, case number 112658 in the matter of Clothier.
May it please the Court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. Your Honor, I'd like to reserve 2 minutes.
2 minutes?
2 minutes, yes.
Okay. For those watching who were not here this morning, as you saw, Justice Biles is recused and Senior Judge Malone is sitting in his stead. All right. Thank you, counsel. Please proceed.
We're here as a result of a hearing that occurred on August 18th of 2014. The respondent appeared at that hearing with counsel, Mr. Ambrosio. The panel actually considered 3 different complaints that day. The first filed by an attorney from Leavenworth County who was on the opposite side of a divorce case with the respondent. That complaint involved the respondent's aggressive behavior towards that attorney, actually outside of a judge's chamber. Also accusations of dishonesty on her part. And there was also, during the course of that proceeding, there was an ex parte contact with the judge. The panel found that, that there were violations of 8.4D, prejudicial to the administration of justice, and 3.5C because of the ex parte contact. Second complaint was filed by a client of the respondent's, arising out of the respondent's representation of that client in a divorce case. There were issues of diligence and communication. There was also an incident at the end of the representation where the respondent used profanity, calling his client profane names during the conversation that led to the termination of the representation. Panel found a violation of 8.4G, which is conduct adversely reflecting on a lawyer's fitness to practice law. And the third complaint was filed by a district court judge in Leavenworth County as a result of comments made to that judge, to various counsel in different hearings, and to litigants in some instances. Those comments are obviously set out in detail in the panel report, including an allegation by the respondent that the judge who filed the complaint had acted in collusion with another lawyer in a case where the respondent was opposing counsel. It was that allegation made in open court that led the district court judge to file the complaint with our office. The panel found violations of 3.5D, conduct degrading to a tribunal, 8.2A, statements made about the judge which were false or made with reckless disregard as to their truthfulness, and 8.4D and G, conduct prejudicial to the administration of justice, and conduct adversely reflecting on the respondent's fitness as a result of comments made to opposing counsel and to various litigants in a number of different cases. Obviously, the misconduct was extensive and serious. The recommendations at the hearing, our office recommended a 6-month suspension with a reinstatement hearing. At the conclusion of that 6 months, the respondent recommended that his plan of probation be adopted, allowing him to continue to practice law. It should be noted that the probation plan was in compliance with the Supreme Court rules. It was, in fact, in place and distributed to the members of the panel and our office prior to the hearing. The panel, citing the respondents, and I quote, significant rehabilitation, unanimously recommended to this court that this court grant the respondent's request for probation. They suggested that probation be 3 years from the date that the court issues its opinion, if that's what the court should desire to do. The respondent has taken no exceptions to the panel's findings or to the rule violations that they found. So those are all deemed admitted. Since the panel hearing, on January 15th of 2015, the respondent has filed with this court an affidavit of compliance regarding his probation plan. The respondent represents in that affidavit that he has complied with all terms of his probation plan, and I have no evidence to the contrary. I would note for the court that there's no evidence of any of the type of conduct that led to this matter coming before this court. Since the final hearing report, and really clear back to May of 2013, which was when Judge Wiley filed his complaint as a result of the allegation of collusion. Today, as I stand before you, for reasons which I will explain to you, I've changed my recommendation. I now recommend a 3-year suspension from the practice of law. I recommend to suspend the imposition of that sanction and place the respondent on probation for 3 years, as recommended by the panel. And the reasons for those changes is as follows. The respondent's conduct since the hearing on August 18th of 2014, there really is no evidence of any sort of this type of misconduct reoccurring. The strict adherence to his probation plan, which is as extensive as a probation plan as I've ever seen. The fact that he has complied with all of it, I think he needs to be given credit for that. There is a letter from his supervising attorney that was sent to me last week. I thought it was part of the record. I guess it's not, but basically Mr. Ronald Bates, and I will file a motion. I've talked to Mr. Ambrosio and responded about this. I'll file a motion to have that letter admitted as part of this record. But it's from Ronald Bates, who's the supervising attorney for the respondent, and they are both in the same building. So they see each other on a daily basis, and I think that's important. I also want to talk a little bit about the mitigating factor of mental disability. There's a lot of evidence in the record about that. There's Dr. Robertson, who's a psychologist who has evaluated the respondent. There's Exhibit P in the respondent's exhibits. There's a lengthy discussion of the evaluation and the diagnosis. And then there is a letter that I received last week from Dr. Robertson, who the respondent meets with 2 times a month, stating that in his opinion, to the extent that they're able to do so, he just doesn't see that this would happen again, this sort of behavior would happen again. In my motion to submit additional evidence for you, I will also include that letter. More importantly about this mitigating factor of a mental disability, it's not very often that the 4 tests are met to have the evidence submitted as a mitigating factor. I mean, there has to be medical testimony that the disability actually exists. That obviously makes sense. There has to be, and there is in this case, there has to be a correlation between the impairment and the misconduct. And Dr. Robertson points out that correlation. And I think it's pretty obvious, even for a layperson like myself, that there was a correlation between the mental disability and the misconduct. There has to be a sustained period of meaningful rehabilitation. And I believe that's occurred. And if you look at the Dr. Robertson's letter just sent to me last week, it's really pretty remarkable what the respondent has done. And then there has to be the professional opinion by Dr. Robertson in this case that the misconduct's not likely to reoccur. And he opines that in his latest letter to me, as well as the letter that was sent or provided to the panel. Finally, I would note the respondent's voluntary absence from the practice of law for 3 months back in 2013, when he, as was suggested to him, entered into an inpatient treatment program for 3 months in Mississippi. So there really has been somewhat of a voluntary suspension from the practice of law for 3 months. All of this leads me to the conclusion that the respondent deserves credit for this. I believe very strongly that the public will be protected, which obviously is our charge. And I think the respondent understands that if anything like this happened again, that there's no wiggle room, there's no leeway here, at least from our office's perspective. I'd be happy to answer any questions.
Counsel, I'd like to look at one of the complainants, Judge Wiley.
Yes, sir.
And some of the allegations that he made that apparently were either admitted by the respondent or were proven at the hearing. I don't need to go into detail, but they seem very disrespectful to a judge in Kansas. And my question, therefore, is, does Judge Wiley have a position about this probation plan? According to what I saw in the record, he believes probation would work for respondent, but has he said anything else about this case?
Well, just his letter of complaint and what is the quote that was from the panel hearing, which was cited in the panel report. I think Judge Wiley was asked whether or not he thought that it would be okay or that this respondent could be successful under this plan of probation, and his response, I think, was one word: yes. But it's obviously an excellent question. Judge King also, who's the administrative judge in that district, also testified at the hearing and was actually, I think, enthusiastic about the prospect of Mr. Clothier practicing because of his experience. So he was also supportive. And I will tell you that the attorney who filed the complaint, the female lawyer who filed the complaint, as a result of what happened outside of Judge Wiley's chambers, if you read the transcript and you read, she testified by telephone, as I recall, she talks about the apology that Mr. Clothier gave to her at the courthouse, which she considered to be what she said was heartfelt, sincere, and she forgave him completely. I really have no evidence, or I can't present to you evidence of somebody on the record saying that this man should not be given a chance to practice law. What he has done, I mean, I never thought I'd be standing here at the time of the hearing or before the hearing suggesting to you that I would change my recommendation, but to me, the evidence is pretty overwhelming that he has rehabilitated himself and he's a productive member of the bar. That was kind of a long answer to your question, Your Honor.
Maybe I'll save my questions for the respondent and his counsel, but the gist of it is whether he has made his peace with Judge Wiley.
I believe that he has.
All right.
Now there is, I think Judge Wiley did testify, I believe it's in the record, that the respondent before the hearing had actually gone in and apologized to Judge Wiley. And the respondent, as I understand it, practices primarily in front of Judge Wiley. His domestic relations practices in front of Judge Wiley.
All right, thank you. Any more questions? Thank you, counsel.
Thank you.
Mr. Chief Justice, Your Honors, may it please the Court, I'm John Ambrosio on behalf of the respondent. I urge you to follow the recommendations of the panel and my colleague in the Disciplinary Administrator's Office. The three complaints that started this problem for the defendant went on for a long time. His behavior for a long time was unconscionable. The things he said to Judge Wiley were bad. This is terrible behavior in the three complaints. The threats to a lawyer that he practices against, the discussions with his clients that were colorful, to say the least, were all bad activities and probably should have led to an indefinite suspension or disbarment, but for the change. And this is one of the biggest and best changes that I have seen in the 15 years that I've been doing disciplinary work. He got involved with KLAP, and KLAP, to its credit, said, we can't help you with just having a sponsor or just going to AA. You have got to go to treatment. I would have bet all the money I had that the man that first came into my office when these complaints first started would have not gone to treatment. And I was surprised, and KLAP was surprised, and his monitor was surprised when he went to treatment on his own nickel to Mississippi. We were all surprised again because they decided, they meaning the treatment people, that 30 days was not enough. And they asked him to stay another 30 and another 30. And to his credit, he stayed for 90 days to his financial and his family's financial detriment, to his practice detriment, but he did it. He stood up to the plate. The change between that first day in my office and the man that I'm now pleased to represent, I can't even explain the difference. He goes to AA 6 and 7 times a week, sometimes more. He goes to a lawyers group in Lawrence where they talk about mental problems and alcoholism a couple times a month. He sees a therapist twice a month to deal with his mental problems. He sponsors somebody, he told Mr. Haslett and I today, now in AA. And maybe more important than that he has made amends to the people that he has hurt. He went to Judge Wiley, and Judge Wiley testified that he apologized for his behavior. And Judge Wiley, to his credit, under subpoena, came down and testified that this is a changed man. He said he was always a good, aggressive lawyer, but he was angry and combative. And now he is still an aggressive and a good lawyer, but the anger is gone, and he's no longer combative with everybody in the courtroom, and he certainly is not combative with the bench. The woman that he threatened to take across the street and have a fist fight, to her credit, and this must be a wonderful place to practice law, Leavenworth, because they all came down for him. She couldn't be here because she had a hearing, and she said, Mr. Ambrosio, get me on the phone and I will testify. And she testified on the phone that she met, that my client approached her, and there's a back hallway in the Leavenworth courthouse, and he wanted to talk to her. And he gave what she described as a heartfelt, believable apology for his behavior. And she said he should be given a chance. He should be able to practice law. He's doing everything his probation supervisor, asked him to do. They're in the same building. They talk about cases on a daily basis. They have regular meetings once a week. Mr. Bates has written a report to Mr. Haslett's office about how his files are, what he's doing to work with his clients. He's got my client writing declination letters on every case. And my client works in a field, that's all he does, domestic law, daily basis in front of Judge Wiley. And he is doing a wonderful job. Judge King, who has been on this court a number of times, indicates that the change is measurable, and he has known my client since they were colleagues in the county attorney's office. The change is just incredible. I don't think anybody would have believed he could make the change, that he would be leading AA meetings, that he would be going to twice a month counseling with a therapist, that he went to marital counseling to make sure that his marriage was strong enough to take this awful time that he's gone through. He's a quality lawyer. He's a good lawyer. I may say that I taught him when I taught at the law school in practice court, and he was aggressive and bright back then, and the man who appeared in my office 2 years ago, at the beginning of his complaints, was not the same just aggressive man, but he was angry, and he was a drinker, and he was mentally ill, and he is dealing with each of those problems on a daily basis. I think Mr. Haslett is right when he has changed his recommendation from 6 months to giving him a chance on the probation. I urge you to follow the probation plan. I urge you to follow every portion of that probation plan. It's okay with the suspension of 3 years, then suspend that imposition and give him the chance to continue to practice law, not in a good fashion, in an aggression fashion, but in a way that is caring to his clients, loving perhaps to his clients, without this animosity and anger that he showed to the bench and to every client. My client would like to address you.
Just one hesitation of several that I have is that you acknowledged at the outset of your discussion with us this morning that this behavior typically would warrant indefinite suspension or even disbarment.
Without question.
And so we're here now talking about a probation plan, the extremes of either end, and it's rare that we would, if ever, we would do that and not acknowledge that this behavior was serious behavior, had implications for the administration of justice for all of us, and not to have some other sanction imposed other than probation.
Well, a suspension is a pretty serious sanction, and then hold off that suspension
Right.
so that he's on probation is a pretty serious sanction. I think anytime you have to appear before the court, and anytime you get any type of discipline, it's serious. Certainly public censure and certainly a suspension and given a chance on probation is pretty serious, Your Honor. I mean, I never discount this as a slap on the wrist the way some people say. This is really serious. And was his conduct caused by his mental illness? The answer is yes. It's in the report. Was his conduct caused by alcoholism? The answer is yes. It's in the record. And has he changed? And in the last 2 years, the change is incredible. And I hear what you're saying. I understand that. I've been worried about this from the beginning. Didn't sleep last night because of the various questions that I think are going to be asked. I understand that. More importantly, it's not important that I understand it. Mr. Clothier understands that now. My client would like to address you, Your Honor.
Certainly.
I'd like to address the court, not just you, Mr. Chief Justice.
May it please the court. I'm Louis Clothier. I'm incredibly ashamed that I'm in front of you today under the present circumstances. I really appreciate the things that Mr. Hazlitt has said. I really appreciate things that my attorney has said. I'm very grateful for the opportunity to practice after I got out of treatment, to practice the tools that I've learned in treatment and in the aftercare program. The behavior that led to the complaints involved arrogance, lack of self-control, anger, a feeling of victimhood, if you can believe that, that I was being treated badly. It was pervasive in my life. I was right, everybody was wrong. I had all the answers. I had all this experience, and anybody who had less, their opinions weren't worth listening to. I was out of control. I was in denial after the first complaint came in. I was in denial after the second complaint came in. I pushed Judge Wiley in the courtroom, and it never crossed my mind that I might be here before you at that time. I thought, I'm just going to push him as far as I could, kind of like I used to push basketball referees when I played ball, till I got a technical or something. I thought, well, maybe I'll get a contempt of court citation, but I'm going to represent this client. That was sick thinking. I was disrespectful. I am so sorry for what I said to him. I apologize to him, but I can't apologize enough. I apologize to Ms. Snyder, but I can't make enough amends to her. I apologize to you for the time you're taking. I apologize to Mr. Hazlitt for his office's time, and Ms. Loveland for investigative actions that voluntary. Apologize to my family. And I don't mean by mentioning them last that they're somehow unimportant. I'm lucky to have a wife that exhibits all the behaviors that I've been learning in AA. Serenity, belief in a higher power, to the extent where she reassures me that whatever happens, that she's going to love me. I'm really blessed to be married to her. I was in denial even when I started treatment. Mr. Ambrosio says that I surprised him by willingness to go. I'd like to claim that I'd had this epiphany, that at that moment I was completely sorry for everything I'd done, but in reality and honestly, in retrospect, I was simply afraid I'd lose my license. I began to change my attitudes in treatment, but it wasn't immediately. About 60 days in, I stood up at a AA meeting, which I went to 6 to 7 times a week, and admitted that based upon everything I'd heard from other people, that I was an alcoholic. You don't want to admit that. It's everybody else's, that drinks, not me. In AA, we had a meeting the other night, and it was on the first step, which is where you admit that you have trouble with alcohol, that you, and paraphrase it, that your life's become unmanageable. It's real hard to make that admission to others, much less, to yourself, much less to others. But that's when I reached the bottom, when I made that admission. Since then, my serenity, my happiness, my humbleness, I learned those things. And I have to say to you that AA, if you have no experience with it, believe me, is a blessing to everyone who has an opportunity to be in that program. It's kind of like group therapy, but it's far more than that. They say keep coming back till you want to come back, and I've reached the point where I want to come back. I want to be of service to others, to my fellow AA members, and that is the ultimate goal. That's the 12th step in AA. I've made amends to people in my life to whom I've been harsh and rude. I'm not just talking the talk. I'm doing my best to walk the walk. And I hope you accept the probation plan that we've submitted. I want a chance to redeem myself. I want a chance to be a mentor to others. I want a chance to be an example to others. In the courtroom, I watch some behaviors from other attorneys, and I recognize myself in them before I went to treatment. I wish I could grab them and say, don't go down that road. Don't go down, that's the left road, the wrong road. Come back and go down the right road. I've got a lot of legal experience to pass on, but now I've got some insight in how to disagree when necessary without being disagreeable. And forgive me for using a trite phrase, but it's the it's the pithy sayings that sustain you all day long. And that's one of them that I use constantly, day in and day out. One last thing. On page 60 of the, in chapter 5 of the Big Book, it states, bear with me, I'm kind of drawing a blank now, and I didn't bring my reminder. We claim spiritual progress, not spiritual perfection. I hope I never make another mistake like I have. Can I guarantee you, I believe Mr. Hazlitt asked me that question, or one of the panel members asked me that question in my hearing. And I said, I can't guarantee it, but I can guarantee I'm going to do my best, and I'm going to go to AA every day that I can and try to gain the tools that I can use to practice every day to be the best person I can be. And I know I've spoken a long period of time, and I apologize for that, but I wanted you to see what's in my heart. Thank you. Oh, I'm sorry.
Wanted to follow up on a question that I think you're probably the only one who can answer. Number one, whether you have been accepted by your colleagues in the Leavenworth County Bar after all these events, whether you've been accepted by your clients, including the one that filed a complaint, and your attorney said that you have reached some accommodation, understanding with Judge Wiley. Could you respond to those three concerns?
My colleagues, couldn't have been more gracious. It's not been mentioned, but I've had the opportunity to go to a number of them with whom I was rude or brusque or and apologized, and they've been very gracious. Clients, the ones I've had since returning over the last 14 months, there's not been a need to apologize. I've acted appropriately. The client who made a complaint on advice of counsel and because he's represented by other counsels, I have not gone to him and apologized. Wanted to. I would love to. I'm not sure he would accept it. But, one of the requirements, one of the steps in AA is to make amends to all those you've hurt. And we discuss in AA a lot of times whether or not they accept it, that you have to do that if you're going to be successful in the program. So I look forward to that opportunity.
Judge Wiley.
I actually went to all the judges and apologized. Judge Wiley, his is the only court I practice in. He's been so gracious. He's acted like there was never any issue between us. He's told me on a number of occasions that there were moments in court that I certainly acted a lot differently than I would have before. And I really am grateful for those comments. It tells me that maybe maybe all this treatment is making a difference. So,
As far as you can tell, he's given you a clean slate.
yes, sir.
All right, thank you. Any more questions for respondent or counsel? I see none. Thank you.
Thank you.
I did request 2 minutes of rebuttal, but I really don't have anything to add unless you have any questions for me.
Any questions? I see none. Thank you. I thank you all for your comments and arguments this morning. Court will take this matter under advisement.